All right, it looks to me like it's slowing down a bit. We have a good number of folks with us now, so we're going to go ahead and jump into it. Welcome again, everybody. Thanks for spending some time with us this afternoon with Adam on this webinar on unlocking ERISA, how to win appeals when the stakes are high. So I had a lot of feedback on this one that people were excited about it. So just some quick housekeeping. If you are having trouble with your computer audio, feel free to call in. You should be able to grab that number. I think I have it on the previous slide here. If anybody wants to grab that real quick, but it is available as well in the controls within GoToWebinar. Just a little bit about who we are for anybody that might be new to these webinars. The Association for Healthcare Denial and Appeal Management. We're the only association that's dedicated to this space of teaching and educating industry professionals who are involved in this process of combating the challenges that you get from the payers and the third-party auditors. Our mission really is to kind of promote a community here of folks that are dealing with these and provide all the education that we can and give you resources that's going to strengthen your fight. Adam is, or this webinar really is kind of being supported in a large part by PayerWatch. A quick note on who they are. There's two parts to the organization of PayerWatch. One's Appeal Masters, which is a appeal writing services arm, and then the other part is Veracity. It's a technology that helps hundreds of hospitals manage that whole process and really make it a lot more streamlined and easy, accelerate the appeal process. So feel free to check that out if there's an interest. We do offer CEUs for today's webinar. There are a couple things you got to meet. You do have to be an Adam member. You have to attend the live webinar for at least 53 minutes, and we are held to that standard to the minute by the accrediting organizations that we serve here. So you got to be on for 53 minutes, and then you must complete the survey at the end that will pop up at the end of this webinar. So make sure you hit all three of those, and then you can get the CEUs. Particular to the CEUs provided by a Medco, I do need to let you know there's no financial or commercial support that we've received from them for this educational activity, and no let me go to the next screen here. We have no conflict of interest to disclose either. There are a few more steps in obtaining that CEU after this, so make sure that you do download this handout. It's in the download sections. If you go to the settings in your webinar screen, you can grab it, but this slide shows you exactly how to make sure you get that CEU. You got to go out to their website, check a couple boxes essentially, and then you got it. Last off here, I do have to read this. If you've been on these, you know that this is a requirement, so I got to read this verbatim. So stick with me. The Association for Healthcare Denial and Appeal Management publishes and distributes materials on its website that are created by our members or invited industry subject matters experts for the benefit of all Adam members. Adam does not certify the accuracy or authority of these materials. These materials are distributed and presented as research information to be used by Adam members in conjunction with other research deemed necessary in the exercise of Adam members' independent professional judgment. Adam claims no liability in relation to reliance on the content of these materials. The views expressed in the materials are the views of the materials authors and do not necessarily represent the views of Adam. Any references are provided for informational purposes only and do not constitute endorsement of any sources. There are no conflicts of interest, again, to declare for any individuals in a position to control the content of this presentation. All right, thanks for sticking with me there. This is just very quickly are the learning objectives for this. Again, you can kind of read through them. These were on all the invites that went out and on the registration page, but take a look at the handout. Make sure you download that. And with that, I'm going to turn things over to our presenter, Dr. Kendall Smith.
Thanks. Just a little bit about myself. I was a hospitalist by training for the past 25 years. a medical director for care management, utilization review, and then background in CDI before joining PairWatch about a decade ago, where I'm currently serving as Chief Medical Officer. So I have a huge interest in the subject today, is what we'll get into with some personal experience. And if you can move forward, Eric, we can start the discussion here. A big caveat, I am not an attorney. I did not go to law school. Everything here today is just a matter of opinion. I'm making no representations that any of this actually would constitute legal advice. I would advise anyone considering what we're talking about today to check with your in-house legal counsel before proceeding. What I am sharing is personal experience gained as both a patient and physician advisor for 20 years. In this field on understanding how to leverage ERISA to your advantage in payment disputes. And next slide. So the foundations of ERISA began back in 1974. And the background for ERISA, if you want to move to the next slide, Eric, was that a number in the late 60s, early 70s, there was the failure of a number of corporate pensions that promised to protect benefits for their enrollees. And these companies went bankrupt. The enrollees were essentially left with nothing. And this monstrous act that's ERISA is actually its own specialty in law, and it's incredibly complex, which is the one thing I want to leave people with as a principle up front, is that this is an incredibly deep and complex area of law that is constantly evolving through legal opinions, lawsuits, etc. There are four pillars that underlie what is known as the Employee Retirement Income Security Act, or ERISA. One is that of disclosure. The big one that I think we're going to talk about today is the concept of fiduciary duty, federal enforcement rules around it, and claims procedure requirements. And probably the most onerous of these and the most vague that I think we can start to leverage as we move forward is the concept of fiduciary duty, which we'll get into. What happened in the 80s, and this is where my personal experience starts to enter into this, was that the Department of Labor confirmed that ERISA applied to really any, quote, employee welfare plan. So that would include employer-sponsored health insurance, disability insurance, retirement plans, and pensions, obviously. The one result of all of this was that ERISA, the federal statute, was able to preempt all other laws on the book and create one national rule book. And the intention behind this, even though and you start to get into this, was to really make it easier and quicker for employees, plan participants, to access their benefits. But as such things often are, the complexity of doing just that ended up with a monster of a beast that today governs almost 2.5 million plans that are covered under this statute. So if you move on, Eric. Kaiser Family Foundation Survey 2023 found that about 2/3 of covered workers are in self-funded plans, 134 million people, and probably the bulk of people that work in hospitals that are listening today are covered under a benefit plan that's controlled by ERISA. One thing that I would say is that your provider payments and disputes, if you don't have an assignment from the patient or an AOR, and we'll get into this a bit later in the talk, is going to hinge on your network contracts. So what we're going to talk about today is moving outside of that contract and what ERISA means in terms of a claim dispute. If you can get an assignment of benefits or an appointment of representation, two distinctly different documents, as we'll get into, what that looks like from the patient standpoint. It's vastly different than your garden variety insurance dispute that you would get into with Humana, Aetna, Blue Cross through your contract arrangements. And the ability to access this alternate pathway is huge, and for both me personally and professionally, has opened up a whole different toolkit in dealing with denials. And I think that's what we're really talking about through these series of talks is providing people with education and tools to start to look at denials in out of the box formats and look to alternate ideas in terms of tackling claims and getting these things paid. Some of these things that I'll show you today, I've got, as I said, personal experience that I'll share with you and work phenomenally well. So why ERISA appeals feel different, and remember, this is when you are appealing, essentially standing in the patient's shoes. This is not you appealing on behalf of the health, the hospital or the provider, but this is a presumption that you've got an assignment of benefits or an appointment, authorization, or representation for the patient. So different features of ERISA appeals, why they feel different. Starts with the self-funded ERISA plan. In that case, the employer is paying the claims from their own finances. They may buy a stop loss insurance to cover high dollar claims, and they use a TPA, a third-party administrator, to pay the claims and pass money back and forth from their accounts to the plan participants and the providers. So it may be very difficult at first blush when you're looking at a claim to figure out if this is actually going to be governed by ERISA. What I'll generally look for is the patient registration sheet. And if the chosen employer on that registration sheet, that's probably the best indicator to me that this plan is going to fall under ERISA. And I should start to think about some of the strategies that we're going to get into here as possibilities if it's going to be a really cantankerous denial or something that I think the TPA, the third-party administrator, did inappropriately. The concept of fiduciaries, I said we'll get into. Basic takeaway is the fiduciary responsibility means that the plan has to act in the best interest of the employee, of the beneficiary. So everything they have to do has to be in the employees or the beneficiary's best interest. That certainly sounds a bit different, I think, from what most of us perceive health insurers doing when we're looking at unjust denials that really don't seem to have a rational basis. Specifically, self-funded plans have to monitor their TPA's behavior. And under both of these, whether it's a fully insured plan where the company, generally smaller companies, are going out and purchasing the insurance and paying the premiums or sharing the premiums with their employees, there's a difference here. So with a fully insured plan where the company has gone out and purchased something on the market that's governed by ERISA, you may have the ability to litigate this both in state or federal court. We're dealing with a self-funded plan, and again, most people that work for hospitals are going to be covered under a self-funded plan. You're generally limited to litigation in federal court, and the remedies are generally limited to payment of denied benefits. And what I hope to be able to show you today is how to get claims resolved without having to resort to litigation. If we can move over to the next slide, I think I'll talk a little bit about my introduction to ERISA. So as a physician, I had been in practice about 15 years in 2010, 2011, had no concept of ERISA until I had a failed spine surgery, back surgery that left me with some neurologic damage as a result of it. And I was covered under a hospital employee benefit welfare plan that included health insurance, disability insurance, life insurance. And anybody that's got health insurance or life insurance or disability insurance through your employer, I can tell you the time to get out the plan documents and read it is not when you need to access the benefits. You should familiarize yourself well ahead of time with the benefits under that plan. And my introduction to ERISA was getting out the disability benefits book And reading through this and seeing that the hospital system that I work for, which is a great system, but the language that was concerning to me is that the system reserved final judgment as to who was entitled to benefits under the plan, and that their decisions would be sort of final or controlling. And that kind of set me off on this sense of panic, which was this realization that I could submit evidence of a disability and they could well make a determination that I wasn't necessarily disabled under the terms of the plan, and I would really have to abide by that decision. And that was a little disconcerting to me because it was not how I believed insurance worked to that point. So for most ERISA governed plans, you'll find language in there that says that the plan sponsor, the people paying for the plan, the healthcare system, Walmart, if Walmart's paying all of this out of their pocket, Amazon, et cetera, reserve final discretion as to benefits. And that means they can decide your claim, and we'll get into how courts look at that decision making and the legal bars to overturn it once a plan does make an adverse decision. The take-home message is that it's a very high bar to overturn if a plan makes an adverse decision. If the plan sponsor, under a reservation of decision-making capacity, comes up with an adverse decision that's well-reasoned based on the facts, it's a very hard bar to overcome in court. So you don't want to get there if you're not otherwise forced to. If we can move on, we'll talk more about fiduciary duty. The four pillars of fiduciary duty, as we mentioned earlier, consist of the ideas of loyalty and prudence. And these, as you look at them, are really non-specific guidelines. And as a result, you can imagine that there's been a lot of litigation surrounding these things. And we can get into couple of case examples here in a bit as to where this has come about. But this, in essence, is what employer-sponsored plans have to do in monitoring and governing their plans. They must act solely in the participant's best interest, and they pay only reasonable plan expenses. Self-explanatory. The duty to monitor TPAs, third-party administrators, and this is something I personally believe that a lot of plans currently are falling short on. My belief in that stems from the fact that I've seen some really egregious denials in the past year for employer-sponsored plans, where I've brought the issue up to the employer and I've showed them a pattern of behavior from the same TPA, and they didn't react to it. So to me, that suggests that this duty to monitor their TPAs to make sure they're making full, fair, and correct decisions, that they're calling claims appropriately, does not seem to be occurring with the regularity that I would expect, considering the legal exposure that can impart to the plan itself. The idea of a co-fiduciary liability, and this is significant because I've had some discussions with HR directors, and generally your point of contact with an employer for questions about a claim under an ERISA policy is going to be HR, and that's generally who I reach out to initially as a director of HR. And some of them have, I think, personally to me, in an uninformed response, told me that they had transferred all of their responsibility for fiduciary liability to their TPAs and that they bore no responsibility. And that's not true at all. They actually bear a full and complete responsibility and can be sued if someone is knowingly assisting, concealing, or failing to remedy another fiduciary's breach. And the thing that I've started to stress of late to some of the HR directors I've intervened with or interacted with in conversations where the outcome hasn't been what a reasonable person would expect, was that there's an idea that they can be held individually liable under a lawsuit, as well as the plan itself. They can be individually named. And obviously, when you get to that point in a discussion, things aren't going well, if you're starting to point out that they may bear some personal liability in this, and their officer's policy, their error and omissions policy, may not necessarily offer coverage for that liability. There's a sort of a catch-22 in the way those professional liability policies are written that may not cover them for these type of acts, and that's by the time I've gotten to that conversation with HR directors, generally we've had to proceed to litigation after that, but we'll talk about that in a bit. So if you want to move on. So this is a recent example. This came out in 2024 in Michigan. I'm sorry, 2025 in Michigan, that where the idea of fiduciary duty. So in this case, Blue Cross was essentially paying claims and then determining fees through a shared savings program, and then profiting by charging up to 30. The allegation is they were profiting by charging up to 30% fees for correcting administrative errors caused by Blue Cross themselves. So they were kind of double dipping. They were running the plan, and then they were charging to correct overcharges under the plan and pocketing the difference is the allegation that's made. But you can see the way that fiduciary responsibilities come back in litigation like this. Such misconduct is prohibited by ERISA, which forbids fiduciaries like Blue Cross of Michigan from engaging in self-dealing or placing their own interests above those of the plans and plan enrollees they serve. So the clear language over and over about fiduciary duty is that the plan has an obligation to make sure that their actions support the plan enrollees financially, that they're not making adverse decisions that would otherwise harm enrollees entitled to benefits under the plan. And if you can move forward. So the one thing that I like about ERISA is it's got some very tight procedural timelines related to it. We'll get into those as we move forward. So when you start an appeal, if you get back, and I can't think of the number of times that I've appealed something and then gotten a response that raises a new issue on the letter back from the insurer. So if you find out that this plan is governed by ERISA, if you're getting a new rationale on appeal that wasn't raised in the initial denial, you automatically get 15 days to respond to what is ostensibly originally a 30 or 60-day deadline. There is a hard and fast rule under ERISA that a missed deadline by the plan, so if they fail to respond in the time required for a response, that all of your appeals are deemed exhausted. So at that point, if the plan required a second or third level appeal before you could file suit against them, or seek outside help from the Employee Benefits Security Administration, which is part of the Department of Labor, you're fully free to do that on day 61 if a response was due on day 60. The other thing that we'll talk about is generally federal courts, and most of this litigation, again, has to be filed in federal court. Take-home message to the wise as someone who's filed a few suits in federal court, it's prohibitively expensive if you do get to that point. But the one thing is that judges generally in federal court will switch to what's known as de novo review, which means that they're free to review all of the facts on the record and come to an opinion instead of looking at an arbitrary and capricious standard, which we'll get into what that definition means, but basically to say, was the plan's decision completely unfounded based on the facts that they had on hand? And those facts can include professional opinions from hired medical directors, for example, that work for the plan that can render decisions based on the medical records present, et cetera, as to whether the care is medically necessary. And they can point to those decisions and rely on them. And the judges really can't overturn them based on the arbitrary and capricious standard, as we'll show you in just a bit. If you move forward, Eric. One of the things that it's a go-to, and we'll get to a checklist for doing this in these plans, is getting plan documents. If you have a AOR or an assignment of benefits for a patient, the plan has to get you the documents within 30 days of your request, or there's a penalty that starts to accrue at $110 a day under federal law. Boilerplate rationales, and I can't think of how many times I've gotten a denial back that just said not medically necessary, and really didn't to get into any specifics. The response from the TPA, from the plan, must cite specific plan terms and the evidence as to why the care is being denied, why the claim is being denied. The other thing that I think we're all dealing with right now, with the violence that occurred late last year with one of United's medical directors, was that there is more and more reticence on peer-to-peers or in denials during emails, informal discussions, in trying to parse out the name and professional qualifications of the physician, medical officer, nurse practitioner, what have you, who is responsible for the denial. That under ERISA, there has to be full transparency as to what's going on with that claim, with that denial. And you're entitled, assuming that you're standing in the patient's shoes with the appropriate paperwork, to know the name and professional qualifications of the person rendering that decision. I can't tell you how frequently, when I've pressed and gotten this information, I have been surprised. I had a case last year with a gentleman with an intracerebral hemorrhage, with an anonymous denial letter that the inpatient care was not medically necessary, refusing to pay for it. Pressed and pressed, could not get information from the plan as to who was behind this. Finally, went back to the fact there was an AOR on file for the patient, made a demand to know who this was, and it turns out it was a gynecologist. Clearly not someone who could render a decision about medical necessity for an intracerebral hemorrhage. As we said earlier, a new rationale or a pivot or bringing up something that didn't exist at the first level, at the second level, gives you 15 days to stop the clock and respond before the plan can issue its final decision. So everything's paused, and you need to work diligently to get documents put together and submitted if they do raise a new issue at the second level. And it's been very rare that I've seen this happen, but it does happen from time to time. Eric, if you could move on. So the summary plan description has to be distributed, and if you're an employer in an employer-sponsored plan, as I would suspect most of you are, you'll get this via an email or a link or something in your annual benefits enrollment package. And generally, these SPDs, as they're known, are 70 to about 150 pages long, and they go through in very specific language what the plan covers and how it covers it. The thing that I would ask that you take away from this is that the payer's medical necessity requirements are basically their interpretation of what the summary plan description allows or requires under that health plan. The payer policies quite often are much more restrictive than when you look at the summary plan description. So unless there's specific language, and we'll get into how this may be buried in the plan, that says something is not covered specifically by the plan in the summary plan description, where it's silent, the SPD is silent or ambiguous, there's a legal construct known as contra profiterum that basically says, since these are contracts of adhesion, these are one-sided contracts where the employer is putting the plan together, that you as a plan participant have no ability to negotiate any of these terms, that if the person who drafted the plan, the company that drafted the plan, failed to specify something and the SPD is ambiguous, it doesn't explicitly say we're not covering this, that that ambiguity has to be construed in favor of the patient. So as an example, CAR T therapy, which is used a lot now in various types of cancers, or proton beam therapy, unless the plan specifically says that we will follow the plan, the SPD specifically mentions following all of the payer's policies and incorporating that language into it. And I'll show you what that statement looks like in just a minute. If it's silent on things like proton beam therapy or CAR T therapy under the SPD, even though the insurer tells you it's not a covered benefit, legally, your position would be, well, the SPD doesn't say anything to the fact that this is not a covered benefit. It doesn't say that they're going to incorporate all of your payer policies as part of the SPD. Therefore, we're going to argue that since it's silent on this specific therapy, that you need to cover it. And if you don't, then I'm going to get the federal government involved and a few other people involved in this. And that conversation generally is fairly illuminating and often is able to move the ball for you. Keep going if you would. So a broad assignment of benefits generally will transfer the appeal rights for a patient under their health plan to the provider. It allows the provider to have what's known as derivative standing. Essentially, it means you can stand in the patient's shoes to pursue their claim. A lot of policies in the past few years have started to put anti-assignment clauses in there where they say specifically that the appeal rights under this policy cannot be assigned. Workarounds in that are actually to get an assignment of representation instead of assignment of benefits, so that you can represent the patient instead of standing in the shoes. And if litigation comes about, you can include the patient in that litigation and as a workaround. If you want to move forward. So the power of attorney or authorized representation, representative form, can bypass the clause, as I mentioned. It appoints the provider to essentially act on behalf of the patient rather than fully and legally transferring the right under it. So this is essentially what we do when we have ALJ hearings for Medicare, is you fill out an AOR form where you're representing the patient. You're not necessarily stepping in fully in their place. Where you're dealing with multi-million-dollar cases, very high 6-7 figure hospital bills, you can consider including the patient as a co-plaintiff in it. General strategy that we set forward as a best practice is, if you can get an AOB and a limited power of attorney up front, you're probably going to be protected if the plan prohibits assignment under this. This has been litigated, and the Third Circuit Court held that a broad AOB conveyed ERISA standing to the provider. This is being decided at different levels in the court with some differing opinions as to this. They essentially dismissed about 10 years ago Aetna's argument that only the patient could sue, saying that doing so would really only create administrative hurdles and really serve no genuine purpose except to put hurdles in place of people seeking payment. So where payers claim your assignment is insufficient or invalid, you can certainly point to this case and disagree with them in your arguments. Go forward if you would, Eric. So the basic take home under this is nobody's going to get rich under an ERISA lawsuit. You're not able to get punitive damages. Plans will often settle to avoid fees and the interest accrual that occurs under an award in court. So if you've got a really clear-cut case where the care was medically necessary, where the TPA has really behaved poorly. And I have any number of those cases recently. We had a webinar last month with a young lady named Anna that I helped with an ERISA appeal with Optum as her TPA, third party administrator for an employer funded health plan. And she had been denied um, treatment for alpha 1 lung deficiency, genetic lung disease causing severe emphysema at the age of 22, which, if untreated, could necessitate a lung transplant. What was so surprising about that case was the initial denial was signed by a family nurse practitioner, signing in the capacity of a medical director. And we approached Optum United with this information, were rebuffed with it, appealed, and on appeal, the TPA upheld the original denial, this time citing as a basis for upholding the denial um, a non-existent requirement for a CT scan. So United claimed, even though the coverage policy didn't set this forward, that she needed a CT scan to get this medication, which cost $10,000 a month. Not true at all. Was surprised because this was one of those rare cases where I talked to the HR director, and it's the only case where the HR director, my opinion, she didn't really understand her responsibilities, and I subsequently found out was not an ERISA attorney. Essentially told me to buzz off and leave them alone, that they didn't want to hear about this. So when you get to the point of litigation in federal court for an ERISA dispute, generally what the judges can do is just award denied benefits, whether it's under a disability policy, whether it's under a health insurance policy, a life insurance policy. But if you can start to have some backdoor discussions, I found in a professional manner and educate the HR department that the TPA is, acting unreasonably or putting them in jeopardy of investigation by the Employee Benefit Security Administration, you're generally going to have work to resolve these things outside of court. There have been cases where the court has stepped in and actually awarded relief other than denied benefits. And this was a case, Verity was a case from 1996, which was really interesting. This actually ended up before the Supreme Court, and a company known as Massey Ferguson, and those of you that live out in the country will remember them as a great tractor company back in the day, had a number of failing business units, and all of these sub companies existed under Massey Ferguson, and they were looking for ways to terminate the benefits of these employees without disrupting employee morale for people that were working in well-performing units. And they came up with the idea of forming another subsidiary, putting its own self-insurance in place, and then getting about 1,500 employees to agree to be covered by this new company, which is a subsidiary of Massey Ferguson. The problem was, and they assured them that their benefits would be safe, their retirements would be safe, everything else, that the company knew from day one that this venture was not financially viable. It apparently, from the get-go, was $46 million in the red. And by year two, the company collapsed financially, was bankrupted. And as a result, the parent company was able to move all the liabilities for these patients' healthcare, retirement plans, and everything off the books, sort of march them on out through this failed venture. And this ended up finally before the Supreme Court, and the Court of Appeals ruled in favor of the workers, found that the parent company, acting as an ERISA fiduciary, had breached its duty of loyalty through a deliberate deception in putting this plan together. And so they ordered appropriate equitable relief, and they ordered that the parent company restore these 1,500 employees back to Massey's original plan, the one that they had been tricked in migrating from. But again, not a financial windfall. Generally, what you're looking at is trying to make people whole for what they would otherwise have been entitled to. Not one of these class action suits where you see $400 million coming out and you're getting a $20 check as one of the participants in it. But the Supreme Court affirmed the appeal court ruling in this, saying that fiduciaries who mislead participants can face reformation of the plan by the court. And this was important, they can face personal financial liability, so they can be held individually liable. There can be the awarding of attorney's fees to the prevailing party. That can be a two-edged sword if you're bringing frivolous litigation, and you're the plaintiff, you're the one suing, and the court finds against you. The court, in its discretion, can award the plan sponsor attorney's fees for fighting your suit in court. So not something you want to proceed in by yourself, but just be aware of it. If you'd move on, Eric, next slide. So the idea of escalation, and I talked earlier, go to the next slide if you would, about involving the Department of Labor, the Employee Benefit Security Administration. And this is generally what I've found to be the best pressure point in dealing with these disputes. So I was very, very surprised in Anna's case when we got hold of the director of HR. And actually, Anna's mom was a health law attorney, had involved the EBSA and asked, from what I understand, for a call between HR, the plan sponsor, and the EBSA, and HR actually declined to talk to the Employee Benefit Security Administration. Completely tells me that the HR director had no idea what their role was as the fiduciary for this plan, and really was putting themselves, I think, in a lot of legal jeopardy with that case. So if you have a conversation, and I've had really good success over the past probably 4 to 5 years, getting hold of HR where the TPA was really acting irrationally. I had a claim during COVID for a 40-year-old patient where the TPA for a multinational corporation was refusing to pay his claim. He 40-year-old that had died as a result of COVID had been on ECMO for almost a month. The hospital had about a $500,000 bill, and the TPA for the plan was refusing to pay it because they wanted to know if there was a second insurance involved, a secondary payer. It had nothing to do with their responsibility to pay the claim whatsoever, and refused to pay the claim as a result, and refused to hear appeals on the claim. So I found the HR director for the company on LinkedIn, reached out to them, had a very pleasant discussion, and said, listen, this is what your TPA is doing. This is what they're telling the surviving family. I would hate to see this come out in the press, and I think you would hate if we had to get the EBSA involved. So I'm calling you in advance and hoping that we can have a collegial discussion here and get this claim paid, and you could direct your TPA, once I show you the evidence here, to pay the claim. So $500,000 claim got paid overnight with that phone call. So these informal discussions where you're saying the TPA is doing something that is not supported by your plan documents, we're getting the runaround from the TPA. They're making irrational decisions, like using a family nurse practitioner signing as a medical director for the plan. And you're calling HR and saying, listen, we don't want to get the Department of Labor involved, but we will if we can't get a satisfactory outcome here. They're generally going to get hives and work with you quickly and professionally to resolve that. Get on the phone with the TPA, get the claim paid. And that's what I really like as a go-to as a non-attorney. To me, it has been the most useful workaround to these types of high dollar claims is identifying who the employer is, getting hold of the director of HR. There's any number of ways you can find them on LinkedIn or Google or any other apps, and reach out to them by email or a phone call. And an informed HR director that understands ERISA will really tend to want to work with you where it's clear that the plan through their TPA has made a really inappropriate or egregious decision. So what you want to have put together, and be able to show the plan sponsor, is really come with your facts. And this is true whether you're going to an ALJ hearing, whether you're going to a peer-to-peer. Approach it really as you would any professional disagreement about payment for an insurance dispute. A timeline chart, gaps in the SPD, where the SPD summary plan description is silent on benefits, and then the fiduciary breach angle. Remember, we've talked about the four pillars of fiduciary responsibility, and show them how they breached um, their responsibilities to the claimant, to the plan participant. Having a discussion first with HR, and then if you're not successful there, you can escalate it online to the EBSA, which you can find at the Department of Labor's website. They'll send a factual inquiry letter, much like as Rochelle Martin talked about in our last webinar, the CMS complaint process, where you're having problems with Medicare Advantage plans. They'll send an inquiry letter from the Department of Labor, and usually at that point, with a well-constructed timeline, the SPD highlighted, the TPA's errors well documented, and in the case of one that I talked about earlier, where I had some back and forth with the HR director that told me to buzz off. I'm sure when that goes to the EBSA or goes to litigation, that will be part of the lawsuit. Will be very interesting. But that factual inquiry letter generally will get them to stop what they're doing and work with you. So I'll generally give the employer a reasonable time, 5 business days, to pay the claim, or to come up with a remediation plan, and give them time to engage with you before you escalate it. I'm not going to call them at 5 o'clock on Friday and say, if I don't hear you back from you at 9 o'clock by Monday, I'm going to escalate this. You want to give them time once you do submit the documents to them, to engage with you. But be firm and be professional. I mean, this is ultimately a contract dispute. And telegraph what you're going to do, and then follow it through. Say, if I'm going to give you 5 days, I'll provide you the documents as relates to this, highlight things for you and make you aware of what's going on. If we don't hear back from you in 5 days, we're going to escalate it, and then escalate it. Copy the EBSA, and generally the ERISA plan will have obtained outside counsel. You may not know initially who that law firm is. But I would generally, as a matter of fact, carbon copy CC the Department of Labor Regional Office, and this will heighten their fiduciary risk and exposure if they're not behaving responsibly. Remember the $110 a day after 30-day penalty that accrues for document requests, and that's helpful to include a penalty log, much like we would a prompt payment demand. Go ahead, Eric. So what counts as relevant documents? This is the mother lode to me under this. Once you get an AOR for a patient or an AOB, assignment of benefits, includes all internal rules, everything that the plan or the reviewer relied on. You're entitled to emails, claim notes, AI output that were considered, generated, or relied upon in making the denial. And that's set forth in federal regulation. And that is a treasure trove of information if you have a high dollar claim. Again, they have to get these documents to you within 30 days of a written request when you're acting in the patient's capacity. All too often now we hear that these are proprietary guidelines, we can't inform you. Not a valid excuse. These do not override the participant's statutory right to getting the material. So if you're getting a pushback from a plan or a TPA, et cetera, that this is proprietary, I can't give it to you, that's a bunch of bull hockey. The one thing that's great about ERISA is it's really set up to support the plan participant in a dispute, and it wants to make that a level playing field. So these rules, these statutes really make it easy to get full transparency into the decision-making process. And once you have all of those documents, you can really start to pick things apart pretty quickly with your higher dollar claims. It's well worth the time to pursue this. Go ahead. So as we said, Silence in an SPD does not equate to an exclusion. The SPD usually will trump payer policy. Um, the insurer guidelines are merely interpretive aids unless incorporated by reference into the SPD. So you need to look in the summary plan description to see whether it does incorporate the payer policy and say that payer policies will govern this plan description. That's generally the phrase that you'll see in this. Hidden anti-assignment clauses. So if this is buried in the fine print, you may have an ability to argue lack of notice, that you weren't made aware of it because it was so buried in the document. It wasn't obvious to you, and you may be able to enforce your AOB or AOR anyway. The one thing that I mentioned about in my personal case early on was granting the insurer sole discretion. And that language can be a bit terrifying if you're the patient that is looking at a large dollar claim. That sole discretion clause, and that's generally going to be present in most ERISA SPDs, says that the plan has sole discretion to determine who's entitled to benefits under the plan, and that their sole discretion is final. That the judge has to use an arbitrary and capricious standard under review, and that's a very high standard to overcome. It just basically has to say, based on the facts present before the plan, was their decision unreasonable. It's not this 5149 percentage points that we're used to saying greater than not. Is it more likely than not that the plan made the wrong decision here? It's a much higher, much more arduous standard to overcome. One of the big things that these plans fall short on, and I think one of the higher dollar denials we see, are mental health claims. And we'll get into the Mental Health Parity Act and Addiction Equity Act here. But basically this says that for mental health benefits, the plan has to provide benefits equivalent to what's provided under the health benefits portion of the plan. These have to be equal. There can't be discrimination. And if you go to the next slide, Eric. We talked about the concept of discretionary authority. De novo review is the default for these, unless the plan grants itself discretionary authority, which most will. De novo review means the judge gets to review the claim in its entirety, all of the facts in the case, and then render a new decision based on the facts as he or she sees them, not look to see whether the plan's decision was reasonable. So it's a very different standard. Some states, California, Texas, and other states, have now passed insurance for employer purchase plans, where the employer goes out and purchases a Blue Cross plan where it's not self-funded, but they're purchasing the benefit from an insurance company that by statute bans discretionary clauses in those insured plans. So you may take a look, depending on the state in which you're practicing, California, Texas, Illinois. I think there's about 11 now that have specific bans on discretionary clauses in insured plans, not self-funded plans on the books. And this applies generally to only insured policies issued or delivered in the state. Go ahead, Eric. Just some take-home reading about arbitrary and capricious. Did they abuse their discretion versus what de novo means? The plaintiff's burden under an arbitrary and capricious standard is very high. They must show that the decision lacked rational support or was clearly unreasonable. De novo review, as I said, is simply proved by preponderance that the benefits were wrongly denied under the plan. Really significant difference. So if you're in a state where the patient has a health insurance plan that was purchased, it's not employer funded, where de novo review is required under state law, much easier to prove in court the patient's entitled to those benefits. So the strategic leverage exists between the two of those. As I said, arbitrary and capricious is harder to win. You're generally focusing on procedural breaches, which can switch the case to a de novo standard. Under a de novo review, there's greater settlement pressure on the sponsor. The court is not going to give them the benefit of the doubt. So keep those in mind as you go forward. Next slide. So we talked briefly about the Mental Health Parity Act, and what this came about is that these plans must maintain a written document. They must do a quantitative analysis, which we'll get into in the next page. And they have to disclose this to the Department of Labor or to you within 45 days of the request, to show that the plan deals with mental health and addiction, substance abuse addiction issues, in a similar way to the benefits provided for other medical illnesses. And if they don't, that's a violation. So I found out that if you're sensing that the psychiatry utilization processes are more stringent than what you're seeing on a med-surg basis, that you can demand the plan's analysis. Majority of plans, probably well over 50%, can't produce a compliant document. And if you can cite that lack of compliance, that's going to get them to want to settle the dispute with you rather than risk Department of Labor penalties for bringing this to light. So if you're dealing with a really unreasonable mental health or substance-based claim, and you've got a feeling that their plan sponsor's not being able to show this to you, by all means request it. And if they can't get it to you, you've got another leverage point here. Move forward, if you would, Eric, and we'll take a look at what this means. The non-quantitative treatment limitation is any benefit that is not expressed numerically, such as a prior author concurrent review requirements, medical necessity, or clinical guidelines. So everything that really we deal with, I think, in terms of medically necessary care. So a plan's requirements for mental health or substance use benefits has to be no more restrictive than those applied to a comparable medical surgical benefits. And they must document that with a written comparative analysis, which, as I said, you're entitled to if you have the patient's rights. You can't request that if you're just acting under the hospital contract. Next slide, we'll wrap this up. So the checklist for hospital appeal teams, make sure you get your plan documents requested on day one. And this presumes that you've got an assignment of benefits and an authorization of representation from the patient. You may want to start to work with your registration folks to get these up front. It's much easier to do than after the fact. I do reach out to families after the fact, and I have been able to get them when I've explained the hospital hasn't been paid. And doing this would help the hospital get paid for their care. Request the full plan, the summary plan description. The full plan is the complete and total plan language. The SPD is the brief portion of it, kind of the take-home language for it. Track every regulatory statutory clock. Log penalty exposures. Remember, $110 per day starting on day 31. Tight assignment language. Make sure that your AOB covers payment and all related ERISA rights, including litigation and fee recovery. And then get a backup power of attorney if the patient has an anti-assignment clause. Probably going to be working with your in-house legal counsel at that point for a high dollar denial. And if you are starting down this avenue, I do not do it by yourself. Make sure legal knows what you're doing. Work with them to develop a strategy to do this. Escalate when rationale is flipped. A new reason at second level appeal is a violation. Demand, and you're entitled to a 2-week rebuttal window. And if they ignore the procedural breach and go on to uphold their denial in that time frame, let the plan sponsor know, and by all means follow through with the EBSA. Over and over again, when I've got the EBSA involved, where communication's broken down with the plan sponsor, I've generally gotten a surprise call from one of the plan sponsors, or an email asking us to contact them so they could resolve it. If you can identify a TPA behaving badly, as I mentioned earlier with the case that I had discussed with Anna, a generally qualified and informed HR director is going to want to engage you informally to limit their personal liability and legal exposure. And that's been my experience the vast majority of times that I have gone through that channel. I have been told occasionally, and really some colorful language, which it really surprises me when HR directors, when you start repeatedly emailing them, reminding them of their fiduciary duties, requesting plan documents, telling them that they have the plan or the company is going to bear some potential legal exposure as a result of their TPA's behaviors, actions, inactions, etc. I've gotten some really colorful language back in emails, and they said email all the transparency of plexiglass and the longevity of styrofoam. So these emails, I'm sure, his attorneys go through the discovery process and ask for the plan documents, and all the communication really start to, when litigation comes about, look a little embarrassing to the HR directors or plan sponsors. So that's the take home I would leave at this point. Eric, if you go to the next slide. We are at PairWatch and Adam starting a campaign called Raise Your Voice. We're collecting real world experiences with health insurance denials. If you go back to the Adam webinar that we did about 6 weeks ago with Tiffany and Anna, those were some of the first stories in this series. I have some other patients that we've helped individually. The goal here is to provide a face to professionals, to patients that have been adversely impacted through health insurance denials. If you'd be willing to be interviewed for this series, the Raise Your Voice campaign, there's an email here, the raiseyourvoice@pairwatch.com. I'm on LinkedIn. If you have any questions, you can email me or connect to me on LinkedIn, and I'd be more than happy to answer them for you. At the end of the day, we're all advocates. We're all working for the same good here, which is to make sure that we're appropriately paid for medically necessary care delivered by the providers with whom we work. We're a community. We're a very rapidly growing community. And I thank everybody attending today for your ongoing and relentless advocacy in this area. So, Eric, I think I've gone the full hour. What I'll do is probably we'll end up doing questions then via email and post them on the website in respect to people's time.
That sounds good. Yep. I was just going to
Yeah,
come on and say that we'll send out the answers to all these questions. We have had a few, and we'll get them to everybody who asked them, as well as to every attendee as well.
perfect. Thank you. Thanks everybody today. Thanks, Eric.
Thanks, everyone. Have a great rest of your afternoon.